From the very start, this case is such a tragedy. A family is shot and killed inside their home in the middle of the night. But 2 kids survived, and they're now telling very different stories about what happened.
Looking at multiple victims at this point.
This is being described by deputies as a family tragedy.
I mean, this is a small, quiet neighborhood that doesn't see police activity. Probably there's not much drama that goes on around here. This is a very significant event.
Within days, the house itself becomes a big part of the story. How did a young girl escape when her parents and siblings were killed? And now investigators are saying a teenager is framing his dead younger brother. Then prosecutors aren't just making accusations against that teenager, they're also saying his defense attorneys misbehaved in the crime scene.
Are you alleging that at this time, when they went in, that this was a crime scene?
Yes, it is the crime scene. It will forever be the crime scene.
No, it wasn't the crime scene, it was the scene of a crime. Those are 2 different things. There's
a lot that needs to be sorted out about this case, starting with who is telling the truth. I'm KOMO News reporter Jeremy Harris. We're going to take you beyond the headlines in the murders of 5 members of the Humiston family here in Washington and the case against their teenage son. Long before he heads to trial, there's already been courtroom drama, with prosecutors and defense attorneys making accusations against each other. And the key next step in the case, will he be tried in adult court? Let's start on the morning of the murders, October 21st, 2024. It was just before 5 a.m. when the first 911 call came in. A 15-year-old boy reporting a shooting at his house on Lake Alice Road. Police reports say that 15-year-old told 911 his younger brother had just shot the whole family, then killed himself. As King County Sheriff deputies race to the scene, a second 911 call comes in, this time from a young girl at a neighbor's house. Also telling dispatchers her brother had just shot the family. But she says it was the 15-year-old brother who did it. The same one who was on the other line with 911.
The homicide investigation is underway after a shooting involving multiple victims inside a home.
This is going to be a tragedy for this neighborhood.
As the news broke, there were few answers in the early hours. Detectives wanted to get a handle on the scene and talk to the surviving kids. The 11-year-old girl had been shot and she was at the hospital. The 15-year-old boy was taken into custody and the community was in shock.
There's no undoing it. There's no going back. There's no fixing it.
By the afternoon, investigators made the announcement. The 15-year-old boy was under arrest for the murder of his parents, Mark and Sarah Humiston, and his siblings, 13-year-old Benjamin, 9-year-old Joshua, and 7-year-old Catherine. The case started to gain national attention. How could a teenager kill his family, and what set it all off? The 15-year-old was charged with 5 counts of aggravated murder. Now, in cases like this, it will take years to get through the court system. As a reporter, I periodically check in the court files to see if anything new has been submitted. In about mid-November, I noticed a new filing from prosecutors, and I was surprised when I opened it because I saw new allegations not against the 15-year-old defendant, but against his public defenders. This was their filing, where prosecutors laid out quite the story about the days after the murders. But first, let's introduce you to some of the key players here. Jason Brookhiser is the prosecutor with King County handling the case. These are the 2 public defenders, Amy Parker on the right and Molly Campera on the left. They were part of the defense team that went inside the crime scene with sheriff's investigators right before the home was released over to the Humiston's family members a few days after the murders. But that visit wasn't quite good enough for the defense attorneys, who soon went to the family with a request. They wanted to get a chance to go back inside the house on Lake Alice Road to do their own crime scene investigation. In a memo, the defense said their earlier visit barely gave them time to do anything, and they needed to bring their own investigators into the home. The answer from the Humiston family was no. The family said they wanted to have crime scene cleaners start their work at the home as soon as possible. So Campera and Parker went back to the court and asked a judge to order the home to be preserved as is and to give them access inside. A judge agreed and set strict limits on what the defense could do inside the home. They could go into the room of the 15-year-old boy and search through his things, but they were restricted from going through the victim's belongings, and they were told not to take anything out of the house. The judge agreed to allow the defense into the house without supervision by the investigators. This will become a very important point later on. The investigators took pictures before and after the defense team's visit to the house on October 29th. The sheriff's investigators now said those pictures proved the defense team broke the judge's order. The investigators claimed their before and after pictures showed that the victim's belongings had been rummaged through and the defense had moved things they were told not to. The prosecutors also claimed these photos showed that a bottle of Clorox wipes had vanished during the defense team's visit.
The whole point of this is that they don't then get to go into the front entryway. When Your Honor is explicit that you get to go into the boys' room only, and only there do you get to handle things.
At a court hearing in early December, Judge Veronica Galvin wanted to get to the bottom of what really happened inside the house during the defense team's visit.
Because clearly there are things that happened in that house that were not permitted by the order.
Brookhiser, the prosecutor, stood by his accusation that the defense had violated the order.
And Your Honor, the whole point of this is that we were very careful, and Your Honor was very careful, and we spent quite a lot of time talking on the record about going into this home, what defense could go through, what they could touch, what they could handle.
Is deeply troubling, Your Honor.
But the boys' defense team had some accusations of their own, saying Brookhiser was completely out of line to file the memo about them without calling them first or asking them for their own version of the events.
They filed a formal motion before Your Honor accusing a veteran officer of this court of the most heinous accusations that could ever be waged against an attorney. They accused her of mishandling evidence, of dishonesty. They went so far as accusing her of stealing a piece of evidence from a crime scene.
Kristen Gestott is representing the teen suspect. She's a private practice attorney who took over the case from the public defenders. She wasn't involved in the October 29th visit, but she says the investigators claimed that the defense broke the order during the visit was completely untrue. She said their own photos showed the Clorox wipes were removed before the defense team set foot inside.
There are 7 different photos, any one of which would have unequivocally shown that their accusations were false. Law enforcement was the ones who moved that Clorox wipes into the closet.
Gestott was incensed by the prosecutors alleging that the defense may have taken those Clorox wipes.
And I want the court to think about that accusation in light of what the state is accusing this young person of. They had already accused him of tampering with evidence, of staging a crime scene. So this Clorox wipes, which we all know is completely irrelevant to anything, to the press and to the media and to the way that they portrayed it in their motion, made it seem like that the defense team was in cahoots to somehow steal evidence that might suggest that he was cleaning up the scene. Now, we all know how grievous an accusation such as that can be, and we can tell just from reading the commentary to all the articles that were published, where on an international level, people are calling for that attorney who the state chose to name in their motion to be disbarred, to be prosecuted, and things far worse that I would never repeat in this court. Same is true for Your Honor. That allegation single-handedly undermined the public's trust in this court. And that they wouldn't apologize to counsel and that they wouldn't apologize to Your Honor is beyond the pale.
The issue before Judge Galvin at this hearing wasn't who was right or wrong, but rather whether the prosecution should be given access to the defense team's work from their visit to the house. Judge Galvin said the house was not an active crime scene when the defense went in.
The court was very clear. The defense team shall not remove any item from the residence. And to be clear, there is no direct allegation that anything was removed. The implied allegations here or that evidence was tampered with. But I remind you, this was not a crime scene. This was the scene of a crime. And so, as the Bard would say, it was much ado about nothing. Because we also know that in entering the residence, in documenting, the sheriff's office also may have moved something. It doesn't mean that they were tampering with evidence that was there. That's not what it means. It means that people took a seat and they moved the backpack. There's no evidence that they searched inside the backpack, that anything was removed from the backpack, any of that. And frankly, I would hope that parties would meet and confer before bringing such accusations. And I understand that the motion is a motion for discovery, but implied within that motion is that there is some misconduct, that there is some behavior that calls into question the ethical obligations of an officer of the court. This court operates under the presumption that all officers of the court are acting in a manner consistent with their ethical duties and obligations. I never thought I'd have to explain the semantics of crime scene versus scene of the crime, because everybody thinks that this was still a live crime scene. It was not, let me repeat, it was not a crime scene any longer. It hadn't been for several days. A myriad of people had gone through there. A myriad of people had touched who knows what. And even the state conceded at prior hearings that there was nothing forensically viable. This court finds that there was no misconduct whatsoever. The documents are clearly shown that any pictures that may have been taken or any gathering of the shoes was de minimis. There was no tampering with any evidence.
So Judge Galvin said no to the prosecutor's request to get the work product of the defense team from their visit to the house. One other really important note at this point in the case, the public defender's office handed off the case to a private attorney's office. The public defenders insisted this had nothing to do with the scandal around their visit to the home. Rather, they said it was because of a staffing shortage in the public defender's office. So with that whole issue about the controversial visit to the house now behind everyone, the next step in the case is going to be whether or not the 15-year-old is going to be tried in adult court. In the state of Washington, the law says that if you're 16 or 17 and you're charged with murder, that case is automatically handled in the adult court system. But here, the defendant is 15 years old, which means that prosecutors are going to have to convince a judge if they want that case moved into the adult court system. That is what prosecutors have said they intend to do. To get some perspective on this process, we went to the Seattle University School of Law and talked with Associate Dean Paul Holland. What's at stake for a juvenile defendant between keeping that case in juvenile court and moving it into the adult system?
They're practically two different lives. If the case remains in juvenile court, then the maximum for the court's jurisdiction would be to the individual's 25th birthday, and they would spend all of that time if they were found guilty, right? If they are found guilty and sentenced, they would be in juvenile facilities with programming designed for young people to help them achieve rehabilitation and successful reintegration in the community. If jurisdiction is declined and the case moves into criminal court, then for someone of this age, or of the age of the 15, or anyone under the age of 18, the individual would be looking at a sentence of a minimum term of 25 years to life. And so they would be able to stay in juvenile facilities until potentially their 25th birthday. But after that, they would be in the Department of Corrections, perhaps earlier than that, depending on a host of things that we can't predict right now. And that 25-year sentence is a minimum.
Who ultimately makes the decision?
Yeah, so it's the juvenile court judge that the case is before, who will hear the evidence from both sides on all the Kent factors, and that will often include things like school records, any sort of mental health issues, if there are any in an individual case, community contacts, right? People who know the accused from the community, as well as often there will be some sort of evaluation psychological evaluation, other things that might be indicated by the individual circumstance. So all that information from both sides presented at an evidentiary hearing, right? So in court, witnesses take the stand, reports are introduced, all this information comes forward. The judge will review all of that, listen to everything that everybody says, the evidence from the witnesses, the arguments from the attorneys, and then make a decision. Much of the modern case law around juvenile justice and about punishment for serious crime focuses on the capacity that young people have to be rehabilitated, that the idea that someone at 15 is going to be very different when they turn 20, 21, 23, and especially 25 as their brain fully develops, as they are given structure and an opportunity to address the issues that brought them into the system.
And along those lines, and I'll end here, there's a big difference between a 15-year-old defendant and an 18-year-old defendant and somebody who's older. That's something that has to be taken into account when looking at the case.
Of course, and that is the way this system is set up, so that the court gets not just the categorical look, 15 is different from 18, but gets a real specific, clear, deep snapshot of this 15-year-old. We all know that 15 is a time of great change in all of our lives when we were that age, and to any young person. And so each of us approaches it and goes through it in a different fashion, but there is a natural progression, and we do know that 15 to 18 to 21, just as a few benchmarks up to 25, we see tremendous growth as a matter of neurological development, as a matter of emotional development. So there's so much capacity for change in young people that it's one of the reasons we have juvenile court in the first place.
Earlier this month, there was a hearing with prosecutors, defense, and the judge in the case. And the prosecutor said they were ready to go, make their case as to why they want this moved into the adult court system. The defense, though, asked for more time. They said they need a little bit more time to get their case ready as to why they think it should stay in the juvenile system. Ultimately, the judge granted their request, so we expect this is now going to be moved to sometime this fall when everybody will be back in court, and they'll argue about what venue should have this case moving forward, whether the juvenile or the adult, and then we expect the judge to make the decision on that. As for the Humiston family, I've been in contact with a lawyer who represents them who said the family doesn't wish to add anything to our reporting.